Hello, everyone. Thanks so much for attending this important webinar on health and addiction law and policies in the wake of recent Supreme Court decisions. My name is Regina LaBelle. I'm a professor at Georgetown University's Graduate School of Arts and Sciences, and I'm also the director of the Addiction and Public Policy Initiative at the O'Neill Institute at Georgetown Law. So I'm joined here today by two esteemed professionals who are so knowledgeable in this issue of administrative and regulatory law. I'll start first with Professor Bridget Dooling. Bridget is with The Ohio State University, and she has extensive experience in administrative law and regulatory policy. She's a prolific legal scholar with a lot of journal articles to her credit. And she was a research professor previously at George Washington University, as well as serving as a practitioner in the Office of Management and Budget, Office of Regulatory Affairs, Information and Regulatory Affairs in the Office of Management and Budget for quite some time. She's active with the Food and Drug Law Institute and currently serves on the editorial board of the Food and Drug Law Journal. So welcome, Bridget.
Thank you so much for having me. I'm excited to be with you today.
Thanks. And then second, we're joined by Andrew Twinamatsiko. Andrew is my colleague at the O'Neill Institute. He is an attorney who is the director of the Health Policy and the Law Initiative at the O'Neill Institute. He works to expand healthcare coverage, affordability, transparency, and equity through his work at the O'Neill Institute. He also was previously with the Public Health Law Center at Mitchell-Hamline School of Law. And prior to that, he worked in collaboration with the California Department of Public Health on their tobacco control program. He was an adjunct professor at Mitchell-Hamline, where he taught public health law and state and local government law. And his scholarly interests are centered around the intersection of anti-Black racism and health policy. So I'm really pleased to be joined today also by Andrew. Thank you.
Thank you.
So today we have over an hour to talk about these plethora of issues that are facing the United States in the wake of Supreme Court decisions. Sorry, I'm advancing my slides. So the first item we're going to talk about is Bridget's going to review just administrative law generally, because we have a lot of people who are attorneys on this call, on this webinar, but not everyone. We want to make sure we're really level setting about administrative law. And then secondly, we're going to go into these two important decisions, Loper Bright Enterprises versus Raimondo and Corner Post Inc. versus Board of Governors of the Federal Reserve System. So first, I'm going to start by asking Bridget the lead question. So, over time, our rules in the addiction policy space, and we're covering not just specifically addiction policy, but we'll also talk about healthcare law more generally. But over time, these rules have been rather static. And one of the examples is one that you've worked on quite a bit, which is the methadone rule. It was in place for 20 years with very minimal changes until recently, till the last year. So given your experience at the Office of Management and Budget, where you had to review all of these rules, can you give us a brief overview of administrative law and why it matters for people who are advocates and interested in the addiction policy space?
Yeah, thank you. I love this question because administrative law is my field. It's my specialty here where I teach at Ohio State, which is why I got the stadium behind me here. But it is quite daunting to, boil down my entire specialty into, 3 to 5 minutes. So we're going to give it a go. But my interest is making sure that you leave this webinar understanding, why do you need to even pay attention to administrative law and what is it? What do we mean when we say that? So if you're in a space that is highly regulated or regulated to any extent at the federal level, it's worth understanding the way that those rules get put into place. Administrative law is is a number of things, but one of the things it covers is basically how courts review what agencies do in their rules. So as we know, Congress legislates. It often gives tasks to agencies to execute the law that Congress creates. And often that involves making rules. And so there are these standards that agencies have to adhere to when they create the rules in response to legislation. And then after agencies make those rules, sometimes they end up in court. And so administrative law is sort of the bundle of legal doctrines that courts have developed to review agency action. We have also been in a period of a lot of change and uncertainty in administrative law. And so that's what we're going to be talking about today, is sort of the latest installments of, what I'm going to say is something like a 10-year-long process that we've been in that's sort of coming to a head in the last few, to revisit the balance of power between Congress, the agencies, and how the courts fit into all of that. So that's kind of like just to situate you in where we are and what we mean when we talk about administrative law. It's that stuff. It's everything from sort of lofty separation of powers types questions where you're thinking about how the courts provide a check on the executive branch and also on Congress, how Congress checks the executive and the judiciary, and how the executive branch is supposed to go about its very monumental task of executing all the laws that Congress gives it. So that's the domain that we're in here. And addiction policy is a great set of facts and policies and policy circumstances that makes it's a good place to sort of see a lot of aspects of administrative law, which is why I find it so fruitful from a research perspective to focus here.
Great. Thanks so much, Bridget. So I failed to mention before, if you have questions, please put them in the Q&A box. We will have time for questions at the end. There's some that we may answer throughout. And there was someone who said that they're having a hard time hearing. So we'll see what we can do about that. This also will be on our YouTube channel after this is done, and we are having this captioned as well. So Andrew, I want to turn it to you to talk about the decision that we are, one of the two decisions. If you could review Loper-Bright, the Loper-Bright decision, and talk about, what are the general outlines of the case and why is this something that matters to all of us? Thanks.
Yeah, I can try to do that. So I have a few slides which I'm going to share. Let's see if folks can see that. Is that something, can people see those? Are we good?
We can see it, but it's not on the presentation view.
Yeah, I just want to change it to presentation.
Okay, let's see here.
I think it's the little guy. Where
Oh,
you
this one?
that little guy, yeah.
Okay.
Yeah.
Yeah. So, I mean, I think, so to start with, there is a federal law, the Magnuson-Stevens Act, that was enacted to address overfishing. And that's what really this case entails. That's what triggers it. Under that law, it requires that the Department of Commerce adopted a regulation that requires fishing boats in the Atlantic to carry third-party monitors. And this was in furtherance of the Act's goals in order to ensure there is conservation in the fishing industry, to ensure that there's not overfishing. So the Department of Commerce, in consultation with local fishing boards, adopted this regulation that required herring fishing boats in the Atlantic to carry fishing monitors. And the interesting thing is that the statute listed three different groups to whom specifically who would specifically pay for the monitors, but it said nothing about the fishing boats in the Atlantic for herring. But what the Department of Commerce did was to adopt that rule anyway for the herring fishing boats. And this really was supposed to supplement federal monitoring funds if they run short by requiring licensed boats to pay for some of the costs of doing the business. And it costs approximately $710 a day. And so the herring fishing boats, of course, protested. They went to the court saying this is illegal. We can't have this. It's killing our business. And the lower courts, applying what is known as the Chevron deference, upheld the rule. They found it reasonable. And what is the Chevron deference? I'll take a step back and address that. And Bridget kind of laid out the background there. But under the Chevron doctrine, a case that was decided in 1984, when a regulation is challenged, a reviewing court has to take a two-step inquiry into it to determine whether that regulation is valid. The first step is to ask whether Congress has spoken precisely on the issue. And if Congress has, then that's the end of the inquiry, no matter how reasonable the agency regulation is. But if Congress hasn't, and the statute is ambiguous or unclear, the courts are supposed to look at the reasoning that the agency that issued the regulation considered. And if that interpretation is reasonable, they're supposed to not second guess the agency's decision, but uphold it. And the reasoning behind the Chevron doctrine is really important. It's rooted in ideas of separation of powers and representative government. The court reasoned that that Chevron is some type of implicit delegation, that by using broad ambiguous terms, Congress implicitly delegates authority to an agency and relies on the agency's expertise to fill up those details. The second reasoning was that agencies are actually representative in the sense that they exist within the executive branch and they're ultimately answerable to an elected executive, the president. If people are unhappy about the regulation, they have ways through which they can hold the executive's feet to the fire, unlike Article 3 judges who are elected for life. So that's the whole background behind Chevron. Even though the lower courts upheld, and these are actually two cases, Loper, Bright, and Relentless, that were consolidated in one. 4 lower courts, District Court in Rhode Island, the DC District Court, and the DC Circuit and the First Circuit, all upheld this rule as reasonable. Unsatisfied with that reasoning, the challengers went to the Supreme Court, and the issue before the Supreme Court was whether Chevron should be overruled or clarified. And I want to take a step back and really kind of situate this case within a broader trajectory towards deregulation and an anti-administrative state posture the courts have taken in the recent years. Although it would seem that these are small family-owned businesses just going about their business, trying to make a living out of herring fishing, these cases are backed by, as the New York Times reported, are backed by special interests and deep pockets. The group, and I put out the petition for writ of certiorari before the Supreme Court. They are presented by Paul DeClement, who's a prolific attorney, has had a fair level of success before the Supreme Court behind the Affordable Care Act, anti-abortion laws, and gun rights. So he's had really a lot of success. And then we have this group, the Cause of Action Institute, that is backed by the billionaire Charles Koch. And so these herring fishers, small herring fishers, they didn't really pay a dime for this case. This case was backed by special interests. So that is really to situate that background to situate this fight legally. And so what does the court do? The court, of course, was eager to overrule Chevron. It hadn't applied Chevron since 2016, and it overruled Chevron, reasoning that Chevron couldn't be reconciled with Section 706 of the Administrative Procedure Act. Under that section, that Section 706, the court said it directs that the courts decide all relevant questions of law. And because Chevron deferred to agencies, the decision deferred to agencies on whether the interpretation is appropriate, it was a usurpation of the province of the court. And the court backed that up by saying that actually when the APA was adopted, it was a codification of Marbury v. Madison. So the court, both the APA and the role of the judiciary under Article 3 buttress the court's reasoning to overrule Chevron. I'm going to stop there. We'll be talking about these cases through our discussion. But one thing actually that I found interesting was 2 weeks after the Loper decision, the AP ran a story about how New England fishermen had been sentenced in a complex hearing in a case that involved herring fraud, which maybe is like, I don't know, to say that maybe we need third-party monitors. Sometimes these people aren't honest about their activities and therefore furthering the objectives of the Magnuson-Stevens Act. Anyway, I'll stop there for now.
Great, thanks for the fish story. So now I wanted the second case is not one that's gotten as much attention as, overturning of Chevron, but is as significant when we're thinking about administrative law and rulemaking. And so with that, I want to turn over to Bridget to discuss the second case we're going to discuss today, which is Corner Post. Thanks.
Yeah, thank you. I will. I think I just want to put an end cap on what Andrew put on the table, which is to say, if you work in addiction policy, you might be thinking to yourself, why do I care about this case about herring fishermen? Which I would understand if you had that question. And one of the fun things about administrative law is that the subject matter is all over the place because it runs the gamut of, every regulatory agency in the United States. And so for me, it's a feature, not a bug, that I get to learn about herring fishermen, but I can understand if you were thinking, am I on the wrong webinar, right? But the point is the rules that come out of these cases end up applying to all kinds of different agencies, including SAMHSA, DEA, the ones that are probably closer to the work that you all might be doing. So the legal principles are changing, not really with addiction policy in mind. I mean, the rules are changing as they apply to the entire administrative state, meaning the entire sort of federal regulatory apparatus. Addiction policy is just one of literally thousands of policy areas that gets kind of caught up in these doctrinal changes at the Supreme Court and beyond. So you don't necessarily need to be a herring fisherman, although I definitely recommend watching the movie Coda, because that gives you a wonderful glimpse of exactly the facts that are at stake in Loper Bright. And they have a dispute in the movie about having observers on their boats. So anyway, all this to say, you're not in the wrong webinar. This is the right webinar. And the second case we were going to talk to you about is called Corner Post. The facts of this one, I think, are not worth sort of doing a deep dive on. We can just talk more about sort of what the case held. So in law, we have this idea of statutes of limitations. I'm sure you're familiar with this, but just in case, it's the idea that you only have so much time to bring certain cases. The rationale for something like a statute of limitations, because you could think of it as, well, this is unjust. If I have a case to bring, I should be able to bring it, whenever. Statute of limitations stands in part for the idea that at some point you want some certainty. So you kind of want to close the books on something that's happened and move forward and not be reaching back, decades into the past when potentially, certain evidence might be missing, et cetera. So it's this idea that, like, if you're going to bring a case, you got to bring it within a certain time period. The exact time period changes in different areas of the law. In administrative law, we have this sort of default statute of limitations of 6 years. And the question that's at issue in Corner Post is, when does that 6 years start to run? So basically, when does the stopwatch start on the statute of limitations for regulatory issues? The way we used to handle it before Corner Post is that you would start the clock, start that 6-year clock running when an agency's final rule was issued. So when it was published in the Federal Register and sort of out there released into the world, that was considered, the start of the clock. What is significant about Corner Post, and that, really changed the game, is that now the 6-year clock starts from the time that someone is injured by that law. So what does that mean? So if you are a firm that did not exist, for example, at the time when an agency issued a rule, let's say an agency issued a rule, in 1980. Well, your firm started in 2023 and you weren't around. You could not have commented at the time on that rule. What this holding, Corner Post, creates is that the 6-year clock starts from when you, the new business that started in 2023, experiences an injury from the rule. This is a game changer because that concept of certainty, this idea that, well, that rule's very old, that's done and dusted, it's settled, that the law is what it is, that is no longer the status quo for administrative law. So this means that older rules, i.e. some, issued in the 70s, 80s, 90s, even the early aughts, are now back potentially reviewable when they would have been limited in the past, right? So before Corner Post came down, plaintiffs really didn't have a lot of tools to reach back and invalidate the rule. There was a way that they could say, as applied to me, we shouldn't apply it to me in my particular circumstance for the following reasons. But with this, what Corner Post allows plaintiffs to do is reach back and potentially invalidate the rule as it applies to everyone. So particularly in a space like addiction policy, where you have a number of rules that really are, from several decades ago, it really does open up some possibility to think about, are there rules that different parties might want to reach back and challenge, and probably challenge in different ways. And so we'll talk a little bit more about this, but those are the two cases that we wanted to put on the table for y'all.
Great, thanks. And some of what this discussion is about today is really making folks think about both the kind of bad things that could happen, but also if there are any possibilities for, as you said, Bridget, there's some really old laws on the books, rules on the books, and should we be thinking about them in a different way? Okay, so I'm going to ask a series of questions to you all, and certainly feel free to, engage with one another. The first question I know is something that when I was doing some research for this, I came across this article in National Affairs from a number of years ago, but I thought that this was an interesting quote. It said in the article that referred to Congress as a peanut gallery, hooting angrily at executive branch regulators, but seldom bothering to commit to the ardors of policy development and substance. And perhaps this has to do with my many years in the executive branch as opposed to ever working in the legislative branch, but I thought it was kind of funny. And also somewhat accurate in this regard. So in the wake of Loper Bright, Congress is supposed to be eliminating ambiguity in legislation and be more proactive in addressing new policy issues. That's something that's might be a challenge for Congress, might be a challenge for the legislative branch right now, given where we're at. But I open it up perhaps first to you, Bridget, to see if you have any thoughts about that.
Yeah, so it's a great question. And just to connect maybe a couple of dots before I really respond. So the idea is that with changing standards of deference, what you're really doing is you're changing basically who's the lead partner in the dance, right? And under Chevron deference, the agency to some extent had the lead when it came to interpreting the law. Under this new case that just came out this past summer, Loper Bright, that Andrew talked about, the courts are meant to have the lead again. And so, of course, the other party in all of this is Congress. And so what Regina's question is getting at is sort of what's Congress's reaction going to be to a court saying, okay, we aren't going to defer as much to agency interpretations. That maybe puts some pressure on Congress to be more specific, to be more clear about what they want the agency to do. And what Regina's question is getting at is, are they up to it, right? Are we sure that they can do it? And there are people who have been arguing that Chevron deference takes the pressure off of Congress, allows them to make these broad delegations where they say, you know, the Secretary of Health and Human Services shall create a program to do X, and then really directing the secretary to fill in all the details through things like rulemaking. And there are some that argue that is too big a delegation for Congress, that Congress really needs to be the one to grapple with certain policy issues and tell the agency what to execute, not to just say, we want a program that does X, but to say it should have these features and work this way, and here are the standards, and here's who gets the benefits, and sort of make some of those tougher policy calls. So the argument for, you know, the court pulling down something like Chevron deference is to try to encourage and stimulate more legislative activity. So that's all preamble to the question Regina actually asked, which was like, are they up for it? And I don't know. I mean, that's one of the things to watch for. I am someone who I really admire Article 1. You know, Congress is essential in our constitutional system, and a more active, more vigorous Congress is something that I would absolutely support. So there's all sorts of proposals to, you know, beef up resources, to give Congress more staff, to kind of create more support inside the institution to make some of these more complex decisions, and to give legislators tools to analyze different proposals and sort of think through options, and also to beef up their oversight, you know, of the administrative state. So it's early days. I mean, we only got this decision a couple of months ago, and I think the kind of changes that we've just been discussing about Congress will take years, if not decades, to sort of bring about. So what's on my mind is kind of what happens in the interim. Like, even if the best case scenario happens and Congress really, you know, pulls up more of a seat at the table and gets more involved in this kind of policymaking, you know, how long is it going to take them to build the institutional muscle to do just that?
And I mean, I will add, I obviously echo what Bridget has said. Yeah, Congress should do that. And the question, though, is how? I mean, we know that the very foundation of Chevron was the realization that Congress seldom has the expertise to address, you know, these issues in health, especially areas like health that are really heavily scientific. We have, you know, just Congress, just like the courts, they're generalists. So they don't have the expertise to address these things. And as Justice Kagan, she pointed this out in her dissent. She says Congress knows that it does not and cannot write perfectly complete regulatory statutes. And let us also remember that actually what precipitated Chevron in the 1980s was a growth in these laws that were aimed at protecting consumers, protecting the environment, and advancing science. We have in the 70s that the enactment of the Clean Air Amendments Act, the establishment of the EPA, the establishment of OSHA, and all these things really required the expert reliance on agencies to effectuate their broader goals. And even though there were calls to, you know, there were some calls today to remember Justice Rehnquist saying that OSHA can't have this authority to regulate benzene in the workplace. We should just have Congress do it. But the idea that the nuance and the nimbleness and the prescience it requires eludes Congress. And even if assuming that Congress had all that, had the expertise, had the nuance, the prospect of getting those specific statutes go through the legislative process successfully through bicameralism and presentment, I don't necessarily think that is really a realistic expectation, especially, again, the reality that we're operating in is the idea that there is partisan gridlock in Congress. We have veto gates, and also those like gridlock that is exacerbated by the same ideas that the Supreme Court has propagated. For example, gutting the Voting Rights Act, green lighting anti-democratic practices like gerrymandering and like really voter dilution. So I think there is so much that is going on that to dream about Congress really coming to that ideal level of legislation is, I don't know, maybe like political fantasy, to be blunt.
Thanks. So one of the issues that both of you raised was kind of, that we have to keep up with the science. And I think that for a long time, addiction policy was based, no offense to the political scientists in the room, it was based more on political science and actual natural science, biological science. So one of the options is, as was mentioned, is how possible is it for Congress to include language in legislation that would specifically defer? How much leeway would that give a regulatory agency? And is that something that should be emphasized more? So I'll let either one of you answer that.
I can take a crack and then Andrew give it a go. So yeah, so there's already some legislation introduced that would attempt to basically put Chevron back in place. It's probably worth talking a little bit about, what is life after Chevron deference? Questions that I imagine many people on this webinar never formulated in their head before, right? But what is the significance of Loper Bright? Like, why does it matter? Because Loper Bright itself does not say, that courts should not take into account the views of agencies, that courts should disregard agency expertise. It doesn't do anything that extreme. It does it just put the judge back in the driver's seat about deciding, what statutes mean and what they don't mean. And so it basically, says to the judge, yeah, you can take what the agency did under advisement, but you can't just defer to it. You have to do your own, the judge, have to do your own independent sort of assessment of what the statute means. So that's kind of what it's gonna look like. And so sorry, I just completely lost my train of thought. Could you give me the question one more time? I keep doing this thing where I backtrack and then I forget what you actually asked me.
Sorry, no, I was asking about the possibility of specifically being more directive, that the regulatory agencies can do more.
Yeah, exactly. Okay, thank you. Thank you so much. So one of the things that Loper Bright did was it actually recognized that there are times when Congress writes language that implies that it actually wants to give an agency quite a bit of running room and leeway to interpret the law. So they'll use language like, shall create such regulations as necessary, to implement this program, or Congress indicates like a very broad type of authority for the agency. Other times Congress will say very specifically, we want this agency to write a rule on this very specific topic, and we want the features to be X and Y and Z. So it's basically encouraging a judge to look at the structure of a statute and say, does this look like a statute where Congress was basically saying, hey, you guys run with the ball? Or where Congress was like, no, we know the exact play we want you to run, and it's this and this and this and this. So if it's the case that Congress used, pretty broad delegation language, then Loper Bright does not stop a judge, from paying attention to that, and they can still do it. So efforts to sort of codify Chevron deference are underway. I mean, you see some legislation, in there already. It is sort of a delicate thing for Congress to tell courts how to review the law, though. And so that's actually a fairly tricky piece of legislation to have to write. But I would expect that we'll continue to see, some efforts to basically put Chevron deference back in place through legislation.
Right. Thanks. Andrew?
Yeah, and I'll echo that. I think it's pretty dicey. That question is really tough. And I think you see that on how the court was careful in its articulation of its reasoning, why it was ending Chevron deference, saying, relying on Section 706 of the APA, but really saying that APA codified the role of the court in overseeing its oversight or in its interpretation of the law, going back to Marbury v. Madison. And so, I mean, Congress enacted the APA. Congress can, address that specific thing. What, Congress giveth, Congress taketh away in that regard. But again, you could be out of the APA frying pan into the Marbury v. Madison fire. And I think, the idea that we've seen a court that is increasingly aggressive in terms of what, and I think one of the things to look, when you see this string of cases that have addressed the administrative state, they don't exist in isolation. They are part of a broader judicial aggrandizement that really makes it hard for agencies to do their job, and also makes it hard for Congress to delegate appropriately. And so and Bridget points to those things about how what the contours that the court drew. There's still Skidmore deference, like, you have the power to persuade, so go ahead and do your job, but you can only persuade us, we're not going to defer to you. But then when we come to specific delegations, including delegations of you can fill up, you can implement a specific statute, fill up these gaps. But I'll give you an example of where that could also run into problems. Say, for example, the EPA is authorized to adopt the best system of emission reduction. And that is actually something that EPA can adopt. Does that mean EPA can, adopt a regulation that authorizes generation shifting from fossil fuels to more renewable energy? The court says that actually violates some other thing called the major questions doctrine. And then take again another example of the Food, Drug, and Cosmetic Act that says, hey, FDA, please regulate drugs and devices. Is nicotine a drug? Cigarettes that deliver nicotine devices that can be regulated? The court has said, no, that violates the major questions doctrine. So there's just a wide range of things through which it's kind of the one thing that maybe I personally find a little is that the court has adopted this "I know it when I see" type of approach to these things, and doesn't really dictate the contours of these doctrines. So there's just goal shifting, in all these arrangements.
Thanks. So I want to go back to pick up, Andrew, if you could talk a little bit more about, given that, what does this portend, or what should advocates be thinking about? And should there be more focus in the courts right now?
I think I've betrayed my skepticism through the comments that I've made. But I think the court left cues, and this, regulatory work is not a walk in the park. There's, studies that have shown regulatory ossification is a real thing, 6 to 8 years for regulation to come into place, especially when it involves, hard questions. And the court, I think, so two things. The court was clear that Skidmore deference stays. So if the interpretive authority of an agency still really carries a lot of weight, and I think putting a lot of time into that ultimately might persuade the court. The court hasn't applied. We've lived in, as Bridget was saying, we've lived in post-Chevron world, at least as far as the Supreme Court is concerned, for the last God knows how many, 8 years. And there have been cases that have gone through the court, even though the court hasn't really applied Chevron, where there have been wins and losses. I'll take for example, HAV Becerra that involved payments to 340B payments. Justice Alito actually straight up asked Don Verrilli, is like, are you asking us to overrule Chevron? And he was like, I don't know, all we want to do is win. The court never cited Chevron in that case, but they still won. So there is a chance that, in all these, even there could be some wins, but I think putting putting huge stock in really more thought and thoroughness in the regulatory rulemaking that could be of importance. And also, again, the court has told us, if we take it at face value, that it will respect duly delegated authority, both explicitly and implicitly. And so there's work that can be done legislatively to hew to those contours as much as possible, not really chill the efforts that advocates can take and, advocating for specific policies and actually asking the court to do so explicitly, and therefore, putting on a little bit of solid ground.
Right. So we shouldn't be looking for quicker rulemaking in the future. I think that's clear. So Bridget, one of the, in the executive branch, technical assistance is provided to Congress on a regular basis. Will that, as we're looking at kind of beefing up congressional expertise, will we also rely more on technical assistance from the executive branch? And is that another kind of avenue throughout this process in a post-Chevron rule world?
Yeah. And just to sort of explain that a little bit more, I mean, technical assistance, and tell me if this is consistent with what you've seen in your career, Regina, but it's the process of consultation between the, folks on the Hill who are working on draft legislation and the executive branch agency or agencies that know the most about the program as it exists right now, or the policy issues, as they exist right now. So through that back and forth, that kind of iterative process, it allows for agencies to say, okay, we understand you want to address this policy problem. Our advice would be that you handle it, this way, not that way, shape it this way, work with this existing authority, add more capacity here, not here, right? So that it's this advice, this implementation advice for how to make the policy goals, sort of come to life and be workable, right? Once they get to the executive branch. So that process of kind of giving that feedback is what I think of as technical assistance. And so in this era, it will be especially important for folks on both sides of that equation to be very clear-eyed about whether they're trying to give, very specific marching orders to the executive branch, or whether they are trying to give, broader swaths of authority, and sort of making a judgment call about, which type of approach seems better for this particular area. And so that, when the agency is handed the piece of legislation by Congress, when it's enacted into law, that the agency is clear on what its mandate is, right? Is it just to do something very narrow? Is it to stand up, a broad, wide-ranging program? And there's going to be different kinds of legal risk, for all of that, as there has always been. But I think it's safe to say that we are in an era where those who would litigate, or those who would sue the government based on different rules should feel emboldened right now. I mean, that all the signs across these administrative law cases, and Andrew mentioned some others, right? It's not just Loper Bright, it's not just corner post. There's this whole sort of slew. We've just been in this arc, the sum of which is that folks looking to, attack either old rules or recently issued rules should, I think, feel like their critiques and their litigation will be reasonably warmly received by the courts. That doesn't mean they're going to win. That doesn't mean they're right all the time. But from an advocacy perspective, the thing that I would be attentive to is, how clear is the agency's legal footing for what they're doing, and how much is the agency taking a risk in doing what it's doing. And this is unfortunately a full employment program for lawyers, but I would encourage, developing some good partnerships with people who have exposure to not just administrative law, but sort of any type of statutory interpretation, and who are willing to actually go back to those older statutes and say, okay, is the agency, on terra firma here? Is it very clear that this is what they're supposed to be doing? Or are they kind of stretching that existing authority to reach something, something that's emerging, some new health threat, right? Something that wasn't really clearly part of what Congress asked them to do. So, just from an advocacy perspective, that's ultimately what I would suggest is making sure that if you are interested in following what agencies are doing, having a piece of that be, okay, what's the statutory authority, underneath that action really look like?
Thanks. Andrew, did you want to pick up on that? Anything more about litigation, full employment for lawyers?
No, I think Bridget covered most of the bases. Thank you.
Okay, great.
Yeah.
So I want to remind folks to put your questions in the Q&A. We have a few, but we're going to put about 20 minutes at the end of this for your time to ask some questions. So Bridget, you talked a little bit about, the kind of strategic thinking in terms of legislative strategies or regulatory strategies. I want to ask two a bit more specific questions. First to Andrew, are there specific healthcare related rules that you want to specifically call out as something people should be thinking about or concerned about?
Well, I mean, I think as I mentioned, there is a great deal of uncertainty, and I think you can always second guess. You can always go to the court and ask the court to second guess an agency's decision or regulation. And I think the idea now, because of the huge shift in the composition of the federal court and the ideological changes, and then coupled with tactics that are related to forum shopping, you can cue Northern District of Texas, where folks can go and challenge a decision with a hope that they'll draw a judge that agrees, that is inclined with them. So I think there's a threat to a lot of regulations. One specific regulation I'd like to call out right now, which is actually being litigated, is HHS's implementation of Section 1557 of the Affordable Care Act, which prohibits discrimination in healthcare programs and activities. And to implement that regulation, HHS issued a rule that broadly defines activities and programs, and also really advances extension of protections to sexual minorities, broadly defining sex-based discrimination to include sexual orientation and gender identity, and actually bringing it up to par with the Supreme Court's decision in Bostock. And that is even really updating the law. But there was a challenge. There's been a challenge to that decision, and right after, I think, Loper was issued on a Friday, and then on a Monday, the decision came out citing Loper Bright, saying that the best interpretation of 1557 was at the time when that, you can change that interpretation. So you even see where an agency gets it right, the court will say, yeah, that was not the interpretation that was there before. So you actually are not even allowed to update that under the new rendering of Loper Bright. So that is an indication of an egregious way, in my opinion, how the court, a lower court that has taken Loper Bright to a whole new level, threatening access to healthcare by marginalized communities, and entrenching gaps in health access.
Thanks. So Bridget, I want to ask you about a couple specific, so there are two before, and then we've got about 9 questions, so I'll go through those. So there are a number of drug and addiction policy rules that might be affected by these decisions. One is the 42 CFR Part 2, which is the privacy rules around someone's addiction history and records. And the other, the new methadone rules, 42 CFR Part 8. And then there are 2 pending rules in the rulemaking process, one on telemedicine for all controlled substances, and there's a new DEA suspicious order rule as well. So what would you say to some of the folks on this webinar? What recommendations would you have for advocates in light of these recent Supreme Court decisions?
Yeah, so I mean, I am a big fan of encouraging advocates to get involved in the public comment process itself, to the extent that these are rules that are, I think these have all been proposed already, but I'm not sure about the last one you mentioned, actually, whether that's actually been proposed or not, as you know.
It was proposed, I think it's under final review.
Okay. So the comment periods for those proposals have closed then, but I think it's just smart practice to be on the lookout for, new proposed regulations and to get your comments in at that stage, if at all possible. In my experience, agencies take those comments very seriously. That doesn't mean that they just do what you ask for, but in my experience, the folks I knew in my over 10 years of government practice took the comment process very seriously and read them closely and deliberate on the comments received. So that is, I know it feels like you're sending a comment into a black box, but in my experience that, those comments really are read and it is a worthwhile experience. So that's in the policymaking process itself. Once the rule is out, I think it would make sense for, the addiction policy space to sort of have a game plan for what if they want to litigate. Right. And so start building those relationships with potential litigators and helping to kind of be on the lookout for litigation pathways to push back, on a rule that where the policy outcome is not acceptable. That's, of course, in addition, in all your spare time to doing the ordinary sort of lobbying work that you do on the Hill, at the state level, et cetera. So basically never sleep and just work all the time. And I mean, the way I'm kidding in part because it seems like there's this never ending, like there's just more and more fronts, sort of opening up, but it's also a really dynamic time and you want to be able to capitalize on some of this uncertainty, some of what's up in the air here may be something that, this community is able to use in order to advance the goals of treatment access. So I think it is a dynamic time. I'd say get to know your friendly neighborhood lawyer and start building those relationships now.
Thanks. There's one rule that's out now for public comment that I want to highlight for folks. It's a new Medicare rule that would change the definition of in custody that would allow for parole and probation, people on parole and probation to receive Medicare, which seems like a no-brainer, but that's what the rule is before CMS right now. It's just been issued. It's they're taking comments for a few more weeks.
And I just can't tell you how many rules are basically just definitions, and that there's just huge policy, throwdowns over the definitions. And that's why, because it determines who's eligible for this or that program. And that can be a life changer, right? A total game changer for different folks. So if you never dreamed that you would spend your professional career arguing about definitions, I just want to say definitions are like where it's at in terms of a lot of policy. So something that sounds terribly dry and technical and like, why are we talking about, encouraging comments on a definition? That's why. It's because it really determines the scope of these programs that are so important.
Right. Well, we dare to be dull at the O'Neill Institute, where we dig into these nerdy topics because they make a difference, and definitions are exactly part of the issue. So we have about 10 questions. We do want to get, I'll get to as many of these as we can. We're going to collect these afterwards and see how we can identify answers to them as well. So the first is with respect to corner posts, does the statute of limitations start running later only for a new entity? Or could it also be an entity that changed its structure or programming such it is now subject to the regulations and harm?
Super great question that I would expect to see some kind of case, fleshing it out, honestly, because corner post didn't give us a lot. I need to read it again, but in my read of it so far, it basically focuses on, new market. The particular of corner post was a new market entrant, so an entity that was new. But I think you raised a great question. What do we mean by new, right?
Yeah.
What if you just added a business line? What if you, so we don't really know yet. But I think that's part of what you're going to see is folks try to test the limits of like, well, who can bring these claims and what do they really, how far really back can they reach? And, all of those sort of details of like, what does this mean? That is sort of what's in my mind up for grabs right now. And that's what makes watching this, such a fruitful use of time. Right.
Andrew, do you have anything else to add?
Yeah, no, I mean, I think, it's all up in the air. And I think the argument is actually that a statute of limitations or a statute of repose. Like if you're a new entrant, like what does it mean for an injury to accrue? Does it accrue to a new, like, is it just only new entrants, or when you, I don't know, adjust your business or gain something different that you find, harmed in one way? So I think I would argue that it opens that up even for existing entrants. If there is something that you can latch on to say, my injury accrued when I did this, then you can be within the 6 years of the statute of limitations, because it doesn't put the statute beyond challenge after the 6 years of it being in existence have passed.
Great, thanks. Second question is, will we start seeing the you all have kind of answered this, but maybe you have more to add. Will we start seeing the administrative state getting more involved in policymaking rather than just implementation? If so, what would be the impact on the nature of laws Congress passes?
I personally think that it's going to create a huge chilling effect on agencies, and I think there is this misconception of the idea that agencies were doing stuff willy-nilly. I mean, Bridget was talking about how agencies take really the comments seriously, and it's just the rulemaking process is really comprehensive, and it's a long and lengthy process. But again, there's going to be more and more, I think, a step back. And no, these are not my words. I think, like Professor Kassanstein really emphasized that there's going to be a huge effect on how agencies leverage their authority before they move forward. So I think, again, a limited amount of regulations that we'll see.
I mean, I think the thing I would add is that agencies do a lot more than issue regulations. And so I think I would expect, some of an agency's policy energy to potentially be rerouted to the other areas that they oversee, whether that's grant making or enforcement or, providing technical assistance to states and other, folks out there. So I think in my mind, the administrative state has long been deeply involved in policymaking and will continue to be. The way in which they do that may shift somewhat, but I don't see agencies generally, pulling back and holding up shop. I mean, their missions are very clear, their statutory mandates are very clear. And so I would expect to continue to see, a robust administrative state. What I would expect some chilling effect too is the extent to which agencies try to use, old statutes written for different kinds of policy problems and trying to use those old statutes to address, new or emerging challenges. I think that's one of the areas where we've seen the courts be very skeptical.
So the next question is about the courts as experts on areas of agency decisions. We're talking about whether Congress has a level of expertise, but really does the judicial branch have the level of expertise as well? Are we expecting judges to be scientists and understand the science or medicine behind an agency decision? And then there's some, a question, the final question is, how might this affect addiction law cases currently wending through the courts? And I don't know, if you have that specific, but it's just a generalized question that we're asking to respond to.
Yeah, I mean, on the question about courts expertise, I think that's a great question. And I think part of what that evokes for me is that agencies make so many different kinds of interpretive choices when they write rules. Some of those are policy calls. Some of those are like, and Justice Kagan's dissent in Loper Bright actually is marvelous on this point. She's sort of like, why would the Supreme Court know better than, FDA about the definition of a protein and what counts as a protein or not? So, or she's got, she had something about, whether
gray squirrels.
Yeah, whether a species of squirrels was distinct from another. I mean, there's no particular reason why, a court would be better positioned to understand the nuance of like different gray squirrels. So, and yet somebody has to figure it out, right? So the idea is, and there's still, even with under Loper Bright, which is the case that came down this summer, there still is an acknowledgement of agency expertise. It's just a question of, how much and whether, courts actually defer to that. But I think across the range of different issues that agencies issue rules on, right? Some of the choices that agencies are making really hinge on the legal interpretation of a term, and some of them don't. And so I think, I hate to just say it's case by case, but I do think we will continue to see a lot of courts defer to agencies on, super technical questions, but I wouldn't say you can bank on that, right? I do think there are some judges out there that through hubris or otherwise feel that they can answer that question just as well as an administrative agency. So I'm not sure, honestly, and that's part of, what's sort of wild about this era is that we are living through this in real time and sort of seeing how all these dynamics are going to manifest.
And again, I'll emphasize, and then again, I'm betraying my skepticism about how these doctrines that elevate the courts and aggrandize them are anti-science and anti-democratic, and they lead to the politicization of science, especially in these cases. I mean, we saw how that played out in abortion medication, how a district court judge in Texas second-guessed the FDA's expertise and disregarded that, relying on dubious blogs. There is the ideological aspect of the courts and how those courts have been elevated, and the court's answer to the Supreme Court's answer in Loper Bright to this type of approach is, hey, there's actually ways through which the courts are equipped to address these things. And as Bridget said, there is going to be a lot of stock that's put in the agency's interpretive expertise. And also, as the court said, hey, amici can play a huge role in helping the courts understand these things, and this is the bread and butter of what the courts do in resolving this. Yeah, undoubtedly, there's going to be more courts called to answer these specific scientific questions, but then there's also room to play for other players, for example, especially in areas that are science heavy, on what role can outside parties like amici play in helping shape the court's decision.
Great. So we have a question about how this translates. We've focused a lot on Congress. How does this translate to state legislatures and state administrative law? Go ahead, Andrew.
Well, so the attack on Chevron actually hasn't just been happening at the federal level. The Heritage Foundation has been sponsoring legislation at different state levels, codifying the same results that came out of Loper Bright. And so there are ways through which the same is taking place in the state at the state level. But also, this is really me just thinking, there is so much that in terms of administrative law, how states look to federal courts in informing their own approach to the administrative processes. And I think there might be a ripple effect in the states on how they will kind of rein in what similarly how the federal government has acted.
Bridget. Okay. So next question is, do you see any agencies proactively amending rulemaking as a result of Chevron?
I mean, what I've seen so far, I mean, it's been actually quite a while since federal agencies cited Chevron. They sort of took themselves out of that game, at least several years ago. So some of the change of Loper Bright is sort of what I would say is sort of priced into the system already. Like it's been clear for a while that we are entering a phase of skepticism, administrative skepticism on the part of the courts. And so agencies haven't necessarily been, sort of pushing for something like Chevron deference. I think it's probably fair to say that there's a lot of work going on inside the executive branch to sort of think about different ways of choosing regulatory projects, of defending those regulatory projects in public and in court. and making some choices, right? Making some informed choices with an eye towards litigation risk. And there will be things where, you know, this administration and subsequent administrations say, let's take the risk, right? Let's give it a go and see what the courts do with it. And there will be some number of actions that where the judgment is actually the risk is too high. Let's not do it this way, right? Let's maybe go back to Congress for additional legislative authority. Let's handle this problem through our other, you know, existing programs. So I think this has certainly amped up the type of conversations that agencies are having internally. But to some extent, the writing's been on the wall for a while for agencies, and they have, in my experience, have been paying attention to this dynamic for at least several years now.
Great. Andrew, anything to add? Okay. So the next question is kind of along the lines of the technical assistance we talked about earlier. Is there potential for these changes to strengthen collaboration between agencies and the legislative branch? And what would need to happen for that to succeed?
I think the answer is yes. I mean, I think this really does put a spotlight on new legislation and the importance of new legislation, the importance of potentially reauthorizing, you know, old statutes that haven't been reauthorized in many, many years, if ever. And I think the agency staff have a huge role to play in that because they've been administering, you know, for programs that already exist, they've been administering that program for potentially decades and have a wealth of experience about what's working, what's not working. And so, you know, legislators would be very wise to work closely with agencies on those kinds of questions, right? Like we have this lofty goal, right? Is this program actually getting it done?
Andrew, anything to add? Yeah, I mean, on an ideal level, yes. And I think, yeah, if that actually turns out to be how it turns out, that's great because the criticism has always been this is that the Congress is passing the buck. And you should be you're the elected representatives, don't pass the buck to bureaucrats. And I think Congress realizes there is value in relying on experts or agencies that they authorize to undertake this thing. So maybe like the realization that collaboration on the back end really helps and concretize those policies, it would be ideal and an ideal way to go about it.
So another question is, how do you see the impact on collaboration and systems thinking among agency courts and Congress to limit ambiguity in policy, increased judicial oversight, potential for increased legal uncertainty, and the impact on enforcement and compliance? In thinking about this from the perspective of an advocate and helping agencies and communities navigate through the wake of these decisions. Any thoughts? That's a great question.
Yeah, I love that question. And I think being able to step away and sort of map the system, think about how the system is overall working is actually a huge service to people in those individual institutions who might be laser focused on just their one piece of it, right? So I do think that's one area where folks on the outside or with a little more perspective can kind of take a step back and say, okay, this is where this is going. So I think that's really important. And I think particularly when you're talking about sort of a realignment of things like separation of powers, that is the best way actually to observe, you know, sort of what's going and to take all of these things, take Loper break, take corner post, take the major questions doctrine, all of this as data points that informs like, okay, how is the system functioning and sort of what are the hydraulics under this doing? So that I don't think that was very informative just to say +1 on doing that type of analysis. And I think that actually can be a real value add when you're trying to think about, okay, I only have limited resources. Where should I put my organization or my own personal energy? I think thinking about them at a systems level makes a lot of sense.
Great. So I'm going to try to get through all of these. One question, perhaps Andrew, you could answer this. Do you expect a huge backlog in the courts? What's the capacity of our courts to review all these older administrative rules?
I mean, I think yes, absolutely yes, and I think like it's the Loper decision is a jolt to the legal system, and I think coupled with the case that Bridget talked about, corner post, that not only focuses on the perspective aspect of regulations adopted going forward, but also how do we even go back? And the court, one of the arguments that was advanced during the litigation of Loper Bright was, hey, we've had 40 years of Chevron, and there's a lot of cases that have been settled on Chevron, and the court said, well, this only applies prospectively unless there's special circumstances. And people can be creative about even challenging more going back to challenge settled regulations. For example, if like a decision was issued or applying Chevron was adopted by the First Circuit, what does that mean for the Fifth Circuit, or what does that mean for a different circuit there? And so there is definitely a prospect of that happening, of unleashing the floodgates of litigation and the backlog in litigation. And so, there's the prospect of that is not really far-fetched.
So I want to take one final question and then turn it over to you for final thoughts. And this question is, what happens in public health emergencies if the rulemaking takes time? Wouldn't it impact measures like lockdowns, vaccine mandates, et cetera?
Yeah, and I'll just chime in to say there's a concept of something called good cause, which is the magic words for it's an emergency and we need to go faster. So agencies have the ability to claim good cause, and they need to substantiate that. They can't just assert it. They need to, well, what is? So a classic example of a good cause justification would be there was just a massive hurricane and we need to get these grant programs stood up to help people with emergency response. So there is the Administrative Procedure Act has built within it a mechanism to expedite things, when there is an emergency, like a public health emergency.
Mm-hmm. Great. Thanks. Okay. So there were only a couple questions we didn't get to. We can answer those offline as well. So I want to turn it first to you, Andrew, and then to Bridget for any final thoughts that you might have.
I think, I don't think that this is the end. I think advocates are going to have to find creative ways of, I know that I was doom and gloom through the conversations, but I think there'll be creative ways through which policies that are forward thinking, that respond to needs on the ground can still be adopted. I think my thought is, the court has left us some clues on what it will accept, including the fact that it will respect the expertise of agencies. It will respect congressional delegations that are both explicit and implicit. So I don't think that it really serves health policy to say, oh, that door is closed, so let's just go home and can't do anything about it. There's other creative ways through which folks can engage, and I think that now the front for policy contestation is going to be in the courts, and if there are ways through which people can figure out how to get their foot in the door in the courts through intervening in legal causes that implicate regulations that affect them, either through that or through the amicus process, that is a way to do it. And then cross collaboration is really important. Folks need to ensure that there's going to work on collaborating and find ways through which they can leverage their networks and partnerships and other stakeholders to continue championing their causes through the courts.
Great, thanks. Bridget?
Yeah, I'll pick up on the theme of collaboration. I mean, we are in a period of a lot of change in administrative law and in the way that, our three branches relate to each other. And that is not something that's going to be, we're not going to be done with that next year. We are still mid-arc and figuring out, how this is all going to work. We had a period of stability for several decades basically in administrative law, and now we are in a cycle of change. And so to me, and when I talk to my students about this, it's like part of the role here is just hanging in there through some of this ambiguity and thinking about how to potentially take advantage of it, right, for what you are trying to achieve, and get creative and revisit, sort of old assumptions about how things get done. And also leveraging each other and leveraging things like the O'Neill Institute and particularly Regina's program and the ability to convene people with lots of different backgrounds. I mean, I was just scrolling through the attendees here, and it's, so many friends from so many different, lenses of addiction policy. And I think this is a place where, sort of community building and broadening the community to perhaps include one or two more lawyers, sorry, it might be a good time for that.
Great. Thanks, Bridget. This was really enlightening. And one of the questions we didn't get to, because it was so big and it would take so much time, is, what really are the implications of this for what we're in the midst of right now with 100,000 people a year dying of overdoses? And, there isn't just one thing, it's everything. And as Bridget and Andrew just raised, this is all about, building bridges and community across government entities, in communities, local communities, and relying on, experts who you might not think about traditionally, regulatory lawyers, those are all individuals who have an important role to play together with community to bring about change. And that's what we try to do here. Thank you so much, Bridget and Andrew, and everyone who hung in with us for this last conversation. Our contact info should be in the chat, and but otherwise we will have this posted, and thanks so much for taking the time to be with us. Have a good day.